Can I start with picking up my Lord's point from yesterday? We've hunted it down, and we think your Lordship is probably right, actually. We've said it again and again, and it was confirmed in the order, but there was never any formal undertaking given. Can I just show my Lords and my Lady perhaps the best place? You've already seen some of it in our pleading. So the core bundle, tab 13, our pleaded position that I think my learned from Mr Hobbs took you to on page 288. It was subparagraph B at the top, yes, and it's in the middle of there where we make it absolutely clear. I repeated it to the judge below several times, and of course you'll have seen that it was embodied in the order that's at tab 4 as a confirmation. So that is tab 4 on page 74. My learned friend Mr Brandreth tells me that's what Mr Hobbs asked for at the hearing, at the form of order hearing after the judgment. So it was embodied as a confirmation that we won't do it. But I take my Lord's point, it's not formally an undertaking to the court, or even to them, actually. But if...
Well, as my Lord Justice Arnold has observed in a number of recent cases, parties change their minds.
I understand.
Despite stating in the strongest terms to the court that they have no intention of taking a licence or of taking infringement proceedings or whatever, they then do it. So that's why normally one expects to see an undertaking to the court which is enforceable.
Indeed, and that's probably what we said it so often, we thought that's what we'd done. And as I made clear to my Lord yesterday, if my friend hasn't ever said that it's not enough, but if my Lords and my Lady think so, then we can make that more formally an undertaking.
Well, as I said yesterday, it seems to me that having said what you said, I'd have thought you would have some difficulties bringing contempt proceedings, but it probably ought to be regularised.
Absolutely, and as I said, we've said it so often, I think both sides thought we had. Certainly my friend hadn't taken any point on that, and it's only my Lord spotting it that has caused us to go away and go back through that entire history.
I understand.
There's far too much for me to show you every time I've said it, or we've said it in a letter, but I thought I'd show you those key ones. So, my Lord and my Lady, I showed you some of the cases that my friend thought good enough to put in the bundle from those early paragraphs in his skeleton, 24 and 25 yesterday. Can we move on to deal with what are said to be the errors that the judge made that are put forward on ground 1? On my reading of my friend's skeleton, we don't get any suggestion of anything like an error until we get to paragraph 30. And that follows on from paragraphs 28 and 29, the first of which points to paragraph 52 of the judgment, specifically saying there that the judge was right, the point being whether to grant declaratory relief, and if so, in what form, is determined by the circumstances as they existed at the hearing. So up to there, and in particular, paragraph 28 says the judge is right. My friends go on in paragraph 29, where they identify 5 aspects of the circumstances, the substance of which is that there were a lot of alleged breaches, a lot of pages of exhibits, and just a 2-day hearing. And they assert that it was an error of principle, that's the start of paragraph 30, it says wrong in principle, to go beyond ruling, quotes, for guidance of the parties on the correct interpretation of the pertinent provisions of paragraphs 2, 3 and 4 of the final order. And the support for this is said to come from the JSC BTA Bank case. Now, that is in tab 6 of the authorities, if we could take it out. It's the freezing injunction case. Importantly, the injunction was in the standard commercial court form, and the dispute was as to the defendant's ability to deal with rights under loan agreements that had been entered into after the court order was made, the money being paid to third parties by the lenders at the defendant's direction. and the claimant sought a declaration that the rights could only be exercised in accordance with the order, and the issue was whether the rights under the loan agreement counted as assets under the standard form court order. We get all of that from the head note. And of course that question didn't depend upon the detail of how the defendant was conducting himself, specifically seemingly entering into the agreements after the order and directing the money to be paid out to third parties. As I've said, it was a standard form order, and the question was whether the order properly construed covered rights under such loans agreements as, quotes, assets. And it's in that context that we see the passages my friend likes at paragraph 30 of his skeleton. He's actually marked a bit more in the authorities bundle. First, the provisions of the order are marked at page 86. And it's actually paragraph 5 of that order that turns out to be key to the outcome. He also marks paragraph 9 on page 88, which sets out what the bank was seeking. And on page 89, my lords and my ladies see 3 points from the Court of Appeal judgment below that are identified. First, the alleged enforcement principle. Second, the flexibility principle. And third, the strict construction principle. And we get to the meat of the marked passages, paragraphs 16 to 19, on page 90 and 91. And this is where we find the short segments of sentences my friend quotes in paragraph 30. In fact, the key bits are in paragraph 16 and 17. Now, paragraph 16 explains that, and this is about 6 lines in by the top hole, that the sole question is what the freezing injunction means and doesn't depend upon any analysis of the defendant's conduct, which we see from the rest of the paragraph was not exactly endearing. And of course, the point being made is that the order will, on its proper meaning, cover loan agreements that a beneficiary can direct to be paid to others in every case, not just as against a defendant one might not have much sympathy for. And that is really the point that's continuing to be made at the start of 17, which is in fact the second segment included by my friend at para 30 of his skeleton. And it's in fact Lord Clark recording what Lord Justice Beatson said, with which he agreed. And the rest of the marked passage goes on to deal with the alleged flexibility principle. And the point being made there, my lords and my ladies, is that it's okay to be making new types of orders to meet new avoidance measures, but one doesn't resort to expansive interpretation of existing orders. That's paragraph 18. And paragraph 19 confirms the approach to injunction construction, which we've in fact got in the judge's judgment too. He set it out by reference to the judgment of Recorder Douglas Campbell KC, citing this Supreme Court judgment. That's in his judgment, just for your note, in paragraph 109. Well, but that's what this case is about, is how you construe, or how they construed that order. What work does my friend seek to put this judgment to in paragraph 30 of his skeleton? How does he say it supports his allegation of what the judge did was wrong in principle? Well, in my submission, the short point is it's just not on point at all. The segments highlighted by my friend in para 30 are basically saying that in that case, the construction of the commercial court standard form freezing injunction ought not to depend upon a view of the defendant's conduct. How that can be said to have anything to do with an argument as to it being wrong in principle to address alleged breaches of the order and granting declaratory relief as to those made out, as opposed to some more limited ruling, we just on this side of the court have not been able to understand. Now, my lords and my ladies see that the argument proceeds, I'm now in my friend's skeleton, paragraph 30, from there, which seems to accept that some form of declaratory relief is appropriate, the guidance type, whatever that is, to paragraph 31, where we're back onto the argument that what the judge did was quasi-contempt proceedings on all the instances that we identified. And the distinction which I understand what's relied upon here to make good a point of principle is the alleged deprivation of the heightened standard of procedural fairness and the strictures of CPR 81. That seemed to be what he said yesterday when he kept saying, if you go the whole hog, that's what you've got to do. And the end of paragraph 31 focuses on the point about issue estoppels potentially being created by the judgment, and reference is made to paragraph 82 of the judgment. And we'll look at that very shortly. But before we do so, can we just pause and take stock of what we see here? The argument is not that no declaratory relief at all is appropriate, but some kind of more general guidance. And the argument is that doing what the judge did deprived the defendants of the heightened standard of procedural fairness. And of course, the short answer to this, we've covered already yesterday, is that any breaches found to have occurred will not be the subject of any contempt application. And the judge had that well in mind and gave that as a reason that there was no prejudice to the defendants. I have in mind paragraph 82 of the judgment itself on page 103, about 5 lines down. And please note this, my lords and my ladies, they don't say that that paragraph is wrong. The guts of the argument, though, is to simply ignore this important point and press on, asserting that there is prejudice. The rest of paragraph 82 is also unimpeachable in my submission. The judge goes on to explain that looking to the future, he's not convinced the judgment would cause prejudice to any contempt application based upon conduct occurring after the judgment. He's getting into stuff that we covered a little bit yesterday. And the first point he makes is findings of fact would have to be proved to the criminal standard, and findings in this judgment wouldn't be admissible. He then quite properly recognises that where the judgment is capable of being relevant is on the question of whether a relevant set of future facts, if proved, will amount to a breach of the order. And this is the issue estoppel point that we touched on yesterday. Crucially, he explains that he can't see how the defendants will be materially prejudiced if they find themselves issue estopped on a question such as the way in which the order applies to a particular set of facts in circumstances where the question will have been fully argued at the hearing of the application. Can I just pause here? Because this is important, not just in this case, but the whole rationale for the Cipriani type application. And the first point to make sure my lords and my lady have very clearly in mind is this, and I think you do. The issue estoppel is only something that might apply to a set of facts in the future. What has occurred in the past will not be subject to any committal application. Only facts in the future could be. Secondly, as I've already mentioned, the judge said here that those future facts would need to be proved to the criminal standard. And of course, all other procedural hoops would apply. There is no deprivation of any safeguard at all for any application brought in respect of future acts. Third, and this is crucial and foreshadowed yesterday in the discussion that we had, the issue estoppel that the judge refers to as possibly arising is no different to how a finding at any trial might give rise to an issue estoppel that is relevant in subsequent applications to commit. In the patent action example I gave yesterday, or in fact any other case where conduct is found to be unlawful at trial and an injunction is in place for the future to stop its repetition, you have that kind of possibility. The kind of situation where it's established particular conduct may not be repeated, that is no prejudice at all. In fact, I go further. It's the very point of the proceedings. It's the very point. Both the trial, so in my patent example, to establish whether a particular use of apparatus fell within a valid patent claim, and an injunction ordered afterwards intended to give effect to that finding of preventing it continuing in the future. The very point of it is to establish it. And here, similarly, a dispute has arisen as to MSD's conduct and whether it's prohibited by the order or not. The very point of this application, the Cipriani procedure, is to have that determined in as low-key a way as possible without resort to the nuclear option of committal, which we've unequivocally given up the right for, as I keep saying. But of course, just as the claimant in my patent example would need the ability to enforce the ruling in the future if a defendant disobeyed, so my clients here. And as I explained to my lords and my lady yesterday, as regard future acts, the situations are exactly equivalent. Exactly equivalent.
Mr. Hobbs' argument seemed to be that there is some special status in a finding of breach of an order because of its serious and pejorative nature of such a finding. And the implication seems to be that even if you're not making a contempt application, the rules in the Part 81 rules ought to be applicable, and or you simply cannot seek a determination that there's a breach unless you're applying for contempt. That seemed to be the gist of what he was saying.
Indeed, that's the as it were, the outcome for which he contends for, and he certainly, in passing, as it were, suggests that there's some stigma attached to the finding. But what he also suggests, which is the real meat of his argument, is that there's an actual real prejudice, a practical prejudice that he suggests. Sorry, if I move this way, your lordship is right behind. So all I can see is a shadow. It's not much. Don't worry, it's not. Sorry. But he's suggesting that there's actual practical prejudice by being deprived of these safeguards. And what I'm trying to do is actually meet the proper, rather than the kind of nebulous, oh, it's always been unfair argument, which he does try to suggest as well. But I'm trying to meet the real point of his suggestion, which is that the CPR Part 81 procedures are there for a reason, and of course they are, and that he's exposed to the things that those procedures are there to stop him being exposed to. And I'm explaining to my lords and my ladies that that's just not the case at all.
Well, Part 81, in its terms, only applies to committal applications.
Exactly.
So the logic of his argument seems to be that you simply cannot seek a determination or declarations that there has been a breach of an order, except the only way you can do it is in
committal.
Yeah, that's
contempt proceedings.
And I think I said that right at the beginning. That's the nub of the argument. He says.
But can I ask you? My understanding is from what he said that's clear from the authorities.
Not at all.
But I'm not sure that we were taken to any authority certainly that said that in terms.
It's not just that no authority says it in terms, but the gist of them, certainly as to the flexibility of when you can grant declaratory relief, is against him.
No. Well, is there much more to it than that?
Well, no, not really.
I mean, why should the court deprive itself of the ability to make determinations of breach of an order short of committal? I mean, it would be a self-denying ordinance that would force parties to go for committal rather than perhaps what might otherwise be a useful determination that something is a breach of the order.
Well, utility is absolutely key. Utility is key.
I think that's part and parcel of the argument that's been put against you, is that it's not useful. The question Mr Hobbs said, I wrote down very early on in his submissions, is whether or not the declaration would serve a useful purpose. And he then went on to elaborate that by saying you normally need criteria to discover a legitimate purpose. I think part of the argument was that the legitimate purpose that has been identified is to know what the ambit is of what you can and can't do, and you don't actually need to claim that somebody is in breach in order to discover that. That, I think, is part of the argument.
And indeed, but really what that argument comes down to is how useful is an exercise in the abstract without looking at particular facts.
Yes.
That's really what that particular argument comes down to. But looking at utility more broadly, my lords and my lady, it's absolutely plain that when there's a dispute between the parties about whether or not something can be carried on with, how can it not be said to be useful to have that determined?
Exactly, because you say, well, if the court has decided that acting in a particular way would be the wrong side of the line, then both parties know that if you continue to act in that way, it will be on the wrong side of the line.
And again, I'm jumping ahead, perhaps encouraged by my lord saying that there's much more to it. There are a few details that I was going to elaborate on. For instance, the submission that my friend made as to in a committee application, he's entitled to rely upon any alternative construction of the order. That's not saying that that's the true construction, it's just saying that as a defence to a committal, at that point, if there's an alternative one that's not completely ruled out of court, then he can rely on it to get out of committal. So it's obviously useful to have that determined outside a committal application. What is the correct construction? Not just are there other ones that are wrong but not completely mad. And so there is a little bit more detail about why it can be useful for certain purposes, but the guts of it is that it is obviously useful, and it is obviously desirable for my clients to be able to do this in a way, because we do have to live with these people on the other side of the court going forward, to do it in the way that's least inflammatory. And it is rather surprising, my submission, to see a defendant saying, you can only complain about this if you apply to send me to prison. Obviously not with a corporate defendant, but the guts of it is that. And that might be, that surprising nature of things might be why in the previous cases, the Cipriani case and the lifestyle equities, that you didn't see counsel, leading counsel appearing for the defendant there, making those points. You had very experienced leading counsel in trademark matters, Miss Himsworth and Mr Alexander, respectively. And they obviously may have missed a point that it's prejudicial, but unlikely. And it is really surprising, I say, to see a defendant there saying, if you're going to complain about what we're doing, I want you to do it where I'm at risk of serious penalties. And that ought to make my lords and my ladies stop and think, why are they doing that? And the reality is, the only thing we can think of is they like the uncertainty. They'd like not to be told. They'd like for it to be up in the air. They'd like to be able to say, well, we've always got the ability to get out of this if we can point to another, albeit wrong but not mad construction. They just want to carry on to make the decisions themselves, and they like the uncertainty.
Well, that doesn't work, I'm afraid, because once the concession is made that it's open to the court to give a declaration as to what the order is and what the scope of the order is, then you're out of that.
To a degree.
Yeah.
To a degree. I mean, I suppose it depends on how far the declaration goes. But I might be wrong.
Your point about the utility of making a declaration in the abstract without pointing to the facts.
Yeah. I might be wrong.
When we come to paragraph H, where the submission is, it means what it says, and it says what it means.
Yes. Well, I'm going to come to that, but exactly, it's a Brexit means Brexit submission. But I think I can actually cut what I was going to say about the rest of ground one relatively short in the light of the exchanges that we've just had. The one extra point that I would draw attention to is that My own friend said orally that he would prefer to go to the Tesla case rather than the Christian Institute case, the one that's referred to later in his skeleton. And he tried to suggest that they're dealing with the same point. Neither of the cases help him in my submission, but they're actually dealing with two very different points. The Christian Institute case is dealing with a European Convention right, which basically requires the law not to be so uncertain as to be considered to be arbitrary. Yeah. And that's got absolutely nothing to do with this case. The fact that a discretion arises on a declaration doesn't make it anything like that. And I'm not surprised he didn't go to the case, because it just doesn't help him. He tried to suggest that the Tesla case is a good substitute for him, and that case was on a completely different point. It was on a point, as two of my lords know, that was on a point where Tesla sought basically a declaration as to FRAND terms that they were entitled to. But the unusual aspect of that case was because they were seeking a pool license. And they were seeking a license from Avanci, the pool that was one that InterDigital were members of. And of course, in the ordinary FRAND case, what you have is a contractual obligation that implementers can enforce. It's actually a contract entered into with standard-setting organisations, but on behalf of third parties. So an implementer can come and enforce it and say, I want to be offered the FRAND terms that you're obliged to offer under that contractual obligation. And certainly as I read the decision, I appreciate I'm at risk of being corrected, but as I read the decision, the result in that case turned on the fact that two members of this court considered that there was no contractual right to a pool licence, certainly as against Avanci.
Well, not against either.
Either of them, indeed. And so there was nothing for the declaration to bite on, no contractual right for it to bite on. Obviously here, there is a legal right to bite on. It's the order and what they are and are not allowed to do. So it doesn't help my friend. I make 2 points about Tesla. It doesn't help my friend at all, but also it's nowhere near the point that he had in his skeleton, the Christian Institute case. It's just a totally different point. So that's probably all I really want to say about ground one, unless my lords and my lady have any questions for me.
No, thank you.
Can I move to ground two? And before we get into the detail of this, can I just give my lords and my lady the bird's eye view? Because there are two limbs to this ground. The first, targeting or use in the United Kingdom, which applies to both breaches of paragraph 2 and paragraph 3. And the second, use in the course of trade in relation to goods and services, or in other words, a contention by my friend that there's no use as a trademark in the United Kingdom. And that's a trademark only point, so arises in respect of paragraph 3 only. And strangely, my learned friend Mr Hobbs rather focused his argument orally on the paragraph 3 point, the trademark specific argument, rather than the point that would apply to both. I know my lords and my lady are alive to the fact that it can't help him.
Although when it came to the facts, Mr Hollingworth's submissions were going very much to the first point.
Indeed. I don't suggest that he's not running both. It was just a peculiarity that my learned friend's submissions appeared to be really focused on that aspect of the argument that actually isn't going to help him unless he can get out of the paragraph 2 targeting as well. Now, in the course of my learned friend Mr Hobbs's submissions, he made submissions to suggest that the judge didn't look at the individual circumstances as to use in relation to goods and services. And that assertion was made quite generally without looking at any individual instance, and it's quite wrong in my submission. My lords and my lady have seen, for example, the judge's consideration of the SDS instances. He specifically considered the particular circumstances for both paragraph 2 and 3 of the order in paragraphs 376 and 377 of the judgment. Now, as my lord just noted, you saw in the context of my learned friend Mr Hollingsworth's submissions reference to the facts of specific instances more generally, and particularly looking at instances that would relate to paragraph 2 as well. Now, those submissions, in my submission, involved a good deal of what Lord Justice Lewison would call island hopping. And in some cases, I have in mind in particular the submissions as to the news releases for that new COVID drug. They came pretty close to a submission that they took a policy decision to breach the order. As an aside, I was also rather surprised that my learned friend Mr Hollingsworth sought to advance a point not in their notice of appeal or skeleton, and in fact not at issue between the parties since the Court of Appeal before, when this matter was up here, as to assessing identity or similarity of goods in respect of which the use was compared to in my specification of my marks. Right back to the Court of Appeal judgment, it's always been accepted that if there is use in relation to goods and services, there won't ever be a way of getting out of infringement. And can I just give my lords and my lady a couple of references as regards that? The first, as I say, is going right back to the Court of Appeal judgment. So I'm now in the supplementary core bundle, tab 2, 241. It's actually page 135. This is where, on that appeal, there was a dispute about partial revocation of the registered marks. And what I'm drawing attention to is about 4 or 5 lines from the end. There was a fight about whether or not the full scope of our register...
I beg your pardon, could you give me the paragraph reference again?
Yes, sorry, it's 241 on page 135.
Thank you.
And I'm looking about 4 or 5 lines from the end where Lord Justice Kitchen is recording that Merck US and my defendants accept that even if successful upon this aspect of the field can have no material effect on the claim for breach of contract or the claim for infringement of trademark. And it's the infringement of trademark part of that I'm referring to. And just so that you understand, what was going on there was that we had a specification for particular types of pharmaceuticals, often just pharmaceuticals, and there was an argument about whether they needed to be narrowed down, a width of claim thing, and they got sent back basically with the judge being told the approach that he should apply, but it was accepted that it was never going to affect the infringement provisions, the infringement argument, and that's why in Mr Justice, or Sir Alistair's remitted issues hearing, we only ever had an argument about whether there was use of, in relation to goods or services. Nobody cared precisely which ones they were, because there was never going to be an argument about whether or not they were close enough to be similar, even if they weren't identical. And in fact, the same approach was taken before the judge. Can I just show my friend, my lords and my lady, the skeleton that they filed before the judge? It's in S3 tab 49. And I need to show you 2 pages there if I can. I need to show you the 2 paragraphs that related to this issue in their skeleton, which is on page 979. It's basically 131 and 132, perhaps 130 as well. And then there's a reference to column B in their annex. And if you go to that, which is on page 985, you can see that the only issue in column B is not used as a trademark in the course of trade. There's no point on similarity. Sorry, maybe I'm taking this too quickly. 985. It's column B. It's a landscape thing. And perhaps most tellingly, a point that I've mentioned at the outset, not in my friend's notice of appeal or skeleton argument, and not surprisingly, because it's just never been something that's been being pressed. So, returning to the broad picture of my friend's arguments and the two limbs, can I orient you in my friend's skeleton as to these matters? The second limb, so the trademark specific point, is dealt with from paragraphs 72 to 78 of that document. And the essence of the argument is, as was run previously, if no goods bearing the mark Merck are put on the market in the UK, not available to the public, the court must conclude that there's no use of the sign Merck in relation to goods and services. So that's where that argument is dealt with. And the first limb, so that's the one applicable to both paragraphs 2 and 3 of the order, is dealt with in a very long section from paragraphs 41 to 71 of my friend's skeleton. And the first half of that section devotes a significant amount of space to explaining what the defendants have done since 2015. And as we say in our skeleton at paragraph 26, it's not contentious. Of course, they've not carried on in exactly the same way since. But that doesn't mean they've fully or adequately complied. And the point of all these paragraphs seems to be to set the scene for the suggestion made at paragraph 53 of my friend's skeleton. And in that paragraph, it suggested that the judge needed to apply afresh the approach to targeting elucidated in the Amazon and Lifestyle Equities case in the Supreme Court, given that it's fact sensitive, and that contrary to that, the judge treated findings made previously in a materially different context as transposable and applicable under the present application. And the guts of the suggestion is Amazon explains it's fact sensitive, and the judge failed to have regard to that and rather just reapplied previous findings without looking afresh. And my submission is that such a characterisation of what the judge did is as untenable as it is unfair to the judge. It's said in paragraph 53 that two places he erroneously transposed previous findings is firstly paragraph 178 to 186, and then again at 482. Can we look at them? Paragraph 178 to 186 are pages 128 to 130. And can I start by pointing out that this is a section of the judgment actually specifically directed to paragraph 3 of the order. My lords and my lady see that at the foot of page 126. If you look at the foot of 126, you see the heading. And that section follows on from a long section specifically concerned with targeting, which starts back at 147 on page 119, which considers the judgment of Lord Justice Kitchen in this court, in this case. That's right through page 119 onto the Argus case on page 120. And the judge turns to the Amazon Lifestyle Equities case at 153. Firstly, at this point, noting that these two summaries in this court that he's just referred to, so that's the Lord Justice Kitchen in this case and Lord Justice Floyd in Argus, were confirmed to be correct by Lord Briggs and Lord Kitchen in their joint judgment. Now, the judge's judgment then addresses, this is paragraph 154, what lifestyle equities said as to the average consumer, and it's actually specifically what my Lord Justice Arnold had to say about the point, and the judge's view that there's nothing in the Supreme Court judgment that undermines what my Lord said about that. And the judge also refers, this is paragraph 156, to what Mr Alexander KC said in his judgment in the banker case at the foot of page 121, before getting into the lifestyle equities Supreme Court judgment proper, which is the middle of page 122 at para 157. Now, the judge considered this judgment very carefully right through to paragraph 171 on page 126. And this section ends with 3 points the judge makes in paras 169 to 171. But before we look at those, I want to highlight just one aspect of the careful analysis leading up to that. At para 161, at the foot of page 123 over to the top of 124, the judge deals with the submission that my friend made as to targeting not being capable of being found if no goods or services are sold under the mark Merck in the UK. And as I understand it, my friend makes much the same point again before my lords and my lady, but now seeks to put it in terms of no use as a trademark. Before the judge it was put as targeting. And they were relying on a passage in the lifestyle equities judgment. It's paragraph 72 set out by the judge at the foot of page 123 and over to the top of page 124. And as the judge rightly said, I'm now in paragraph 162 of the judgment. This was all in the context of a dispute over US branded goods offered for sale on the Amazon website. The only issue was whether the offer for sale was targeted to the United Kingdom. And the judge correctly noted in the middle of paragraph 162 that they were not saying that targeted could not be found in the different factual context of promotion of goods and services from a US website. Indeed, as the judge correctly went on to note, the decision of this court, also Lord Kitchen, made it clear that it could be. And my lords and my lady know that can be so when, as in this case, the goods and services in the UK actually bear the mark MSD, not Merck. And the reference in paragraph 162 there is to paragraph 153 of the decision of this court in these proceedings. Can we quickly turn it up, please? Keep the judgment of the judge out, but can we take the supplementary core bundle, tab 2, and look at paragraph 153. It's at the foot of page 113. This is the introduction to the section on targeting. And it's clear from this paragraph that it's not to the point that no goods were sold or supplied under or by reference to the Merck sign. Lord Justice Kitchen expressly notes that this was not contended for, and goes on, in fact, over the following paragraphs, to address the issue of targeting in that context. And this is for both the contract and the trademark aspect of the case as we accept it.
Well, the judge quoted that paragraph in 148.
Exactly. Yeah. Yeah, my lord's right. And can I then turn to the 3 points the judge made at the end of his discussion of that case, of the lifestyle equities case? So I'm now back in the judgment, and we need paragraph 169 at the foot of page 125. So he's gone through lifestyle equities, looked at it very carefully, and then he makes 3 points at the end. The first paragraph, particularly over on the top of page 126, draws attention to the fact that the lifestyle equities Supreme Court judgment didn't disapprove of what had been said in earlier cases on targeting. So that specifically includes Lord Justice Kitchen in these proceedings and Lord Justice Floyd in Argos. The judge also referred to the reference to PAMA and emphasised, this is about 6 or 7 lines from the end of 169, that there was a need to carry out an evaluation of all the relevant circumstances, a requirement that was not new in the action. He specifically draws attention to the fact that the PAMA case was relied upon previously, as was the need to take account of all relevant circumstances, as one sees in paragraph 170 referred to. The PAMA case is a very old case. It's not actually even a trademark case. The judge's point, right at the end of paragraph 169, is that the Supreme Court has simply affirmed it. Now, the second point the judge made, this is his 170, is what must be done is carry out a multifactorial assessment of all relevant circumstances. And that leads to his third, paragraph 171, which is to emphasise that this is a fact-sensitive inquiry. The judge specifically says, in working through the rows, it is necessary to make an overall assessment of the relevant websites online and media uses complained of. My lords and my lady, unimpeachable in my submission. The judge goes on in para 171 and explains that the result in the case of any particular row is not necessarily dictated by a case such as lifestyle equities, which was decided by reference to a different factual matrix. And he emphasises the varied nature of the complaints in the rows. So even in this case, they are varied. And the paragraph ends by the judge drawing attention to the fact that these complaints were not confined to the process of marketing and sale of goods through a website, which is essentially what was under consideration in lifestyle equities. So my lord and my lady, that is the section of the judgment that leads up to the section on what must be shown under paragraph 3 of the order, within which the paragraphs my friend rely upon are located. And can we pick it up at the top of page 128, where the judge sets out the key parts of the Court of Appeal judgment in this case, which identifies why targeting and use in the course of trade in relation to goods and services is a requirement, the trademark part of the order. So this is paragraphs 176 to 177. That's what he's doing there. He identifies why it's necessary. And that brings me to the start of the first set of paragraphs where my friend criticises the judge. So I've now got you, having shown you the context, of where they say the judge is transposing, just transposing earlier facts, findings. 178 is where my friend's series of paragraphs start. Now that paragraph refers to the fact that Sir Alistair considered the question of trademark infringement at some length and sets out the context within which Sir Alistair explained he was doing that. And the text set out here explains the suite of global websites and the like. And the judge also notes, this is para 179 at the top of page 129, that Sir Alistair made the point that Merck US never sold or supplied goods or services under the Merck sign. And the text set out here goes on to explain the use of which complaint is of the use of MSD and the use by MSD and Merck US of Merck in promotional and informational material in the course of general commercial activities. And the judge says in para 180 that this paragraph of Sir Alistair's judgment was of particular importance in relation to the application for the reasons he's already identified in the section on lifestyle equities. My lady and my lords will recall I drew attention to the submission my friend was making, saying that that meant that this feature meant my client's case failed. Now the judge goes on here in paragraph 180 to record that it remained the case that Merck US have never sold or supplied goods or services in the UK under or by reference to the Merck sign. So that remains the case. It was the case before, it was relied upon before, unsuccessfully, and it's relied upon again. And as he says, the goods and services continue to be sold or supplied under the MSD brand, in the sense that that's the mark they bear. As an aside, I was surprised that my friend made a submission yesterday. The judge didn't identify any goods being sold here. He did it there, for example. The ones referred to are the MSD branded goods. But it was not a big point because it's always been common ground that they have business here. We all know that they're selling the same goods that they sell in America but under a different brand. But just to pick up a point that my friend sought to make, that he never ever identified them, he's doing exactly that here. We also see the reason the judge considered paragraph 27 of Sir Alistair's judgment important. I'm now at line 6 of para 180. And it's this, because nevertheless Sir Alistair confirmed that infringement of the marks could be found, and was found in certain circumstances, by the use of Merck in promotional and informational material in the course of general commercial activities. And the end of paragraph 180 refers to the fact that Sir Alistair rejected the argument that there could be no use in the course of trade in relation to goods and services. My lords, my lady, that is perfectly fair, and it's an entirely correct point to make. And it's an important point given the argument being advanced. Reading on in para 181, the judge sets out what Sir Alistair identified as the question that had to be answered in light of the previous judgment in this court. And please note the underlined text at the foot of the page, over the top of page 130. This is emphasis added by the judge. And what that part of the extract is doing is explaining how there can be use in the course of trade in relation to goods and services, even without the sign being affixed to them. It's where a link is created between the sign and the goods and services marketed by the defendant. So what the judge is doing here is explaining that this feature of the application before him, the absence of goods and being sold under and supplied with the mark actually affixed, was also the case when Sir Alistair was considering the matter. And paragraph 182 builds on that to explain that the core submission that my clients advanced before Sir Alistair remained our core submission on the application before the judge, and he sets it out. And it did. Paragraph 183 identifies how the reasonably informed consumer was characterised before Sir Alistair, it being the mind of that individual that one is looking through in assessing the existence or not of the link. And then at paragraph 184 on page 131, we see the judge sets out a submission made by my learned friend about the need to take account of context. One does not simply look at an individual web page in isolation. Please note the judge accepted this point in principle. This is 3 lines from the end. And he goes on to say how far it affects the analysis in relation to any particular row is a fact-sensitive inquiry. He's doing exactly what he should be doing.
Well, then you get to 186, which makes it absolutely plain that he's not transposing fact finding.
Well, yes. Yes.
I mean, you've just taken us painstakingly through a whole section in which the judge is just looking at seeing the legal approach and the correct legal approach and how it applies, what Sir Alistair said about it, and he's saying, well, that's the approach informed by what the Supreme Court has said since that I'm going to apply.
Yeah.
Look at it on a holistic basis by reference to the consumer. But I find that's helpful guidance. Well, you'd say there's nothing wrong with that.
There's absolutely nothing wrong with it. Indeed. And as you go through, you see that he emphasises the fact-sensitive nature of the exercise, and he can see it is useful guidance, and there's absolutely nothing wrong with it. And there's nothing objectionable in any of it. And it certainly can't be said the judge was transposing any finding from before and adopting it. He's actually saying the opposite. His task relates to different complaints and it's fact sensitive. And moreover, what I say is the fact that different outcomes were arrived at for different rows, some sharing some similar characteristics, only serves to emphasise that the judge did undertake a separate fact-sensitive analysis for each. The second place my friends say, in their paragraph 53, that the judge erroneously transposed findings from the earlier factual context is paragraph 482. And here it's said he wrongly took from what this court previously said. 482 of the judgment is on page 191. And this is a paragraph in the section of the judgment concerned with the use of a pop-up, basically as a fig leaf, when content is posted that they know will be looked at by users outside their permitted territory, including the UK. It's actually directed to the news releases, sometimes called company statements, that you've heard a bit about yesterday. And it's actually directed to both paragraphs 2 and 3 of the order, so it's primarily concerned with targeting the UK, which is applicable to both paragraphs. My lords and my lady need to see the context of this paragraph. It's within the section of the judgment concerned with what is row EE, starting on page 187. And you see the issue was, as you heard about yesterday, links on the MSD website to news releases or company statements hosted at the Merck US website. And they all relate to that drug that I'm afraid I just can't say the name. It's molnupiravir, I think, which was particularly prominent during the pandemic that my learned friend Mr Hollingsworth referred to yesterday. And the judge explained how a user of the MSD website is guided to the Merck website where the news release or statements are found. And you'll remember Mr Hollingsworth explained how this was a deliberate policy decision yesterday. Somewhat to our surprise, I have to say, apparently seeking to make that into a virtue. And the user passes through a pop-up, or in some cases two, telling them that they're being diverted to a website intended only for US residents. This is all set out in the paragraphs on page 188, and the user ends up looking at the news release or company statement in their location on the Merck website, which has extensive use of Merck and presented in a Merck branded environment. See that noted at paragraph 470. And the judge identified the issues that were raised by this complaint at 471, which for our purposes on this point are that it's not used in the UK, i.e. no targeting. They also relied on 4B, and I'll come back to that on ground 3. That turns on a point of construction. And the paragraph my friend relies upon later in this segment is directed to the no targeting part of the argument. And the judge sets out the MSD evidence from para 473 onwards, and the key things to pick up are in the extracts at 473, Miss Choi's paragraph 17 and the start of 18 explains the news releases and company statements were issued in the US. That involves placing them on the Merck website. And the last sentence of her paragraph 18, I think you might have looked at this yesterday, explains that there was significant interest in COVID-19, so they showed, quotes, showed headlines about the drug on the MSD website. So only headlines on the MSD website. It's in fact the title of the news release or statement, as we see from the extract from her para 20 that the judge sets out on his para 474. And the way this was done was to give the title with a clickable link from the MSD website. So if you wanted to read it, you clicked on it. And as we've covered, that involved going through the pop-up. So there's no doubt, my lords and my lady, firstly, this is deliberate. Secondly, they knew the public to whom the MSD website was directed would be interested, which obviously includes the UK. And thirdly, they intended them to have access to the material only on the Merck website, which, as I've said, is surrounded by the Merck branding. And the only thing my friends were praying in aid was the pop-up, both as falling within paragraph 4B and as a matter of principle on targeting, as Mr Hollingsworth sought to submit yesterday, somehow trumping the obvious targeting otherwise, that those news releases were intended to be viewed by the public to whom the MSD website is targeted. Now the judge actually dealt with the subparagraph 4B point first, i.e. whether they could claim the protection of that provision. That's 475 to 478, and we can skip over that for the moment because it's a ground 3 point. And he turns to the general question of whether the links constituted the breach of paragraph 2 anyway. And the judge records that it was open to MSD to rely upon the pop-up he'd identified in support of the argument that the material wasn't targeted by reason of the links. This is his para 479. And he goes on to say, rightly, I think, that the fact that subpara B is not available, as he had decided, doesn't mean that the MSD defendants can't rely upon the pop-ups in support of their argument. Although I would say the very existence of paragraph 4B in the order is rather predicated on the fact that a pop-up inserted for display to a user who clicks on a link deliberately included assumes that it would not as a matter of principle normally trump what would otherwise be obvious, an intention that the MSD website users would avail themselves of the link. But anyway, there it is. The judge, I think, is strictly right that they can at least rely upon it to advance the argument. That is the substance of the contention. that the pop-up somehow trumps it, even though the link's put there obviously intending people to click on it and look at what you get. And the judge explains, this is paragraph 480, that his view is that the pop-ups were insufficient. And he says he's got two reasons. And the essence of this is his analysis of the evidence. So he's looking carefully at the facts, and he draws attention to the fact that this was a deliberate policy. And by this means having the news releases only on the Merck website. He also draws attention to the fact that it was not an accident that there were links to them were included on the MSD website. And he goes on, 2 lines from the end of the page, to explain that if a user on the MSD website wanted to read these materials, a route was provided to the Merck website by the links. Moving over to page 191, he explains that this route being provided was on the evidence of MSD witnesses Miss Choi and Miss Ronaldo intentional. All this is unimpeachable, my lords and my lady. The defendants provided a route to the Merck website and it was deliberate. It sounds a lot like targeting to us on this side of the court. And he further explains in para 481 that the news releases and company statements were produced for the purpose of promoting the first defendant's business to third parties, who included users in the United Kingdom, as the MSD website was intended for users everywhere outside the permitted territories. And finally, in 481, he says the MSD website was intended to provide the required link to the Merck websites for the user wanting to read the news releases and company statements.
Well, I'm just asking myself the fairly straightforward question. If it was intended only for people, customers in Canada and the USA, why would they be using the MSD website anyway?
Well, they're not. That's the real problem for my friend. They put it on the MSD website, who are UK and other places outside America. And what that discloses is that they intend and they know that people outside of US and Canada will want to read it. And
That's the whole point. I mean, the pop-up is a contradiction in terms, because you've got a pop-up which says this is only for use in USA and Canada.
Yeah.
And yet you've got people who are going to be clicking on the link who won't be in the USA and Canada.
And what do? They carry on.
Forgive me, I mean, this seems to me to be fairly simplistic, but
well,
it seems to me to be a complete answer.
My lady refers to it as a contradiction in terms. It was referred to in the judgment in the Court of Appeal by, I don't know whether Lord Justice Kitchen was using the term himself or referring to somebody else using it, but certainly in that context you'll see it's referred to as a fig leaf. Mm. And I think the sentiment's the same. And the judge says at the end of the paragraph we were on, which I think it's 481, that the pop-ups provide the user with information about where the user was going, but the user had to keep going to read the relevant material, which I think is just the point that my lady's just put to me. And so the judge's conclusion, which you can actually see expressed 5 lines from the end of para 481, was that the pop-ups didn't have any effect on his analysis. So that's his first reason. His second is the paragraph my friend likes and complains about, is paragraph 482. And in this paragraph, he refers to how Lord Justice Kitchen dealt with the reasoning of Mr Justice Norris. And that reasoning, summarised in the 2 paragraphs from Lord Justice Kitchen's judgment, it's set out by the judge, was in substance that providing for terms of use of a website, so I think strictly not a pop-up, but providing for terms of use, stating that it was US users only, which I think is on the pop-up that we're talking about now, but substantially the same thing, stating it was for US users only was just a fig leaf as against what was really going on. And my lady and my lord see the phrase used 4 lines from the end of the quoted paragraph 187. And the judge notes, this is 483, that Lord Justice Kitchen approved that reasoning, and the judge says that that reasoning and Lord Justice Kitchen's reasoning both support the conclusion that on the basis of the relevant evidence, the use of pop-ups quoted could not and did not avoid the news releases and company statements being targeted at the UK through links available on the MSD website.
What he's not doing is applying any fact findings by Lord Justice Kitchen or Mr Justice Norris and saying, well, on those facts, it's only a fig leaf. What he's saying is this is reasoning that they've provided as to why it might not be an answer. I'm applying that reasoning to the evidence on the relevant evidence, which is the evidence before me, and I've come to the conclusion that the use of the pop-ups did not avoid the news release.
Bang on, my lady.
I mean,
Exactly right.
yes.
Adrian. Will your lordships forgive me for just, while we have this paragraph open in front of us, this was a bone of contention in the court below. It's a bone of contention now. My learned friend keeps saying that the expression fig leaf is applicable to the pop-ups. If you actually look at what the Court of Appeal said, it's explicitly related to the terms of use. That fig leaf expression is not directed to the pop-up. We corrected this with my learned friend in the court below, and he continues to say that the fig leaf is on the pop-up, which it isn't.
My submission is that through these whole series of paragraphs, there's absolutely nothing objectionable about this, lady. The judge is expressly not transposing a finding from a previous hearing. He's referring to reasoning which he says supports the view that he's taken in his first reasoning. And that first reason is basically setting out quite a detailed analysis of the facts. Now, there's another strand to my friend's ground 2 argument that appears heavily based on the lifestyle equities judgment, at least in his skeleton. I don't think I developed it all. What I have in mind is that the discussion of it from paras 58 to 64, and the point seems to me to be this. Other than emphasising the fact sensitivity of the inquiry, something the judge had fully on board, appears to be the point made in paragraph 64. This is at the foot of page 37, over to the top of page 38. And the contention is that the lifestyle equities case fundamental to the Supreme Court's appraisal of the Amazon website was a pop-up which triggered when it detected a UK visitor, which was significant because it basically informed the user the website was intended for that user. Basically said you could buy some of the goods. It was making clear the goods offered for sale could be bought and would be supplied to a customer in the UK. And so my friends argue, they say, logically, it cannot be less significant and important where the website triggers a pop-up telling the user that the website is not intended for him or her. Now, I apprehend that my lords and my lady will understand that there's a very big difference. Not only is the context of the debate very different in lifestyle equities, as the judge had fully appreciated, that was about offering for sale goods, it's easy to see how a positive statement that the goods being offered in the lifestyle case would be supplied is very significant, whereas a pop-up that simply asserts the website is for the US is much less significant, but basically for the reasons that my lady just articulated. It's a very different thing, the negative, where you're actually given a link and this told you this is the way to go and read this. An attempt to assert a negative may likely have nowhere near the same significance, particularly when it may be viewed as a fig leaf to try to counter the real-life indicators that the material is targeted at people in the UK. It is different in kind in my submission. And the example that we've just been looking at it and I've been debating with my lady, illustrates that very well. In fact, the evidence out of the mouths of their own witnesses was to the effect that the news releases were of interest to the public outside the US. So then inserting a pop-up saying this isn't for you when you know that's where they're going to go just doesn't do it in my submission. So we submit that the contention in paragraph 66 and 67, this particular strand to the ground 2 argument, is simply misconceived. The next paragraph in this grounds section, 68, is short and sweet and equally misconceived in my submission. The paragraph claims that there needs to be a stage-by-stage approach, which then sets out subparagraphs A to C, none of which have got anything to do with the question of whether in fact the defendants' online materials are in fact targeted to the UK. What they rely upon is an assertion they're entitled to have their own US website. But such website is not open to objection under the order if and while they're not targeted to the UK. I pause and note, indeed, but that simply begs the question. And the third point is that they're not required to make the foreign website invisible or inaccessible to the UK internet users. They're not required. That is an option for them, the geo-blocking.
Paragraph 5 of the order says in terms that geo-blocking means it won't be a breach.
Indeed. But it's not a requirement in the sense that if you don't, you're inevitably in breach, but it's a way of complying. Yeah. None of this is relevant to the question of whether or not they are targeting. It all completely misses the point. They've agreed not to use the Merck name in the UK, and that is prohibited both by the contract and by my client's trademarks, and under the paragraphs of the order. And none of that is relevant to the question of whether or not they are breaching those obligations and the order. My lords, my lady, the final paragraph on page 38, I mean, this is painstaking, but I do have to do it, I'm afraid. The final paragraph on that page refers again to the need to avoid a simplistic approach to targeting and to examine the journey. The paragraph includes a quote as to advertisements for goods. That's not particularly apt for our case, as I've already covered. And it goes on to explain that this approach precludes treating individual items of content on websites as determinative or decisive to the question of targeting.
Your point is the judge didn't do that.
Indeed. I also can't help but remark that this might be thought to be somewhat ironic in the light of the submission made at the top of the page to the effect that a pop-up trumps all. But my main point is exactly the point that my lady puts to me. The judge was alive to this and he didn't adopt a simplistic approach at all, so it doesn't help my friends. Now, my lords and my lady know my friend's complaints say it bites on 3 rows, or the 3 categories. I think a couple of them are pairs that he identifies on page 39. They're said to all be subject to the quotes, the foregoing errors. They don't actually say which ones apply to which. I've already dealt in some detail with row EE, the final one of the 3. Row FF that's put here is materially the same as you heard yesterday, certainly as regards targeting. It's just the link from an MSD website dedicated to COVID. And indeed, my friend doesn't identify any separate paragraph from the judgment concerning FF where there's supposed to be an error. So can I turn to the other instances identified? First, row P and HH. As you heard yesterday, these are job advertisements, and they're dealt with in the judgment from para 355 to 369. So over 3 pages, pages 165 through to 167. And the reason there are two entries is row P, I think this was touched on yesterday, row P relates to listing of jobs located in the UK on the website jobsmerck.com with Merck branding, and row HH relates to a chatbot that operates at that website, which will serve up UK located jobs to a person describing themselves as located in the United Kingdom and interested in jobs in the EMEA region. The latter details explained by the judge at paragraph 364 for your note. And before we go any further, I do just pause and invite my lords and my ladies to note that people describing themselves as located in the United Kingdom and interested in jobs in the EMEA, and ask yourself, why is a chatbot operating on the basis that it's supposedly US located users only? Why is it even set up to do this? To accept somebody saying they're in the UK? That in itself
Unless they want to emigrate to America.
Perhaps, I suppose. But then it would be irrelevant that you're located in the UK. I mean, they set it up not just that you're in the UK, but you're in the UK and you're interested in jobs in the European region, so not the American region. Now, the judge's assessment for both these rows was in substance the same, and I didn't detect from my friends really say there's any difference. Certainly in their skeleton they treated them as in substance the same. And the complaint is that the judge made an appealable error in his conclusion that the reality is that a person searching for Merck jobs in the UK would have found the jobs.merck.com website. That is part of the judge's assessment in paragraph 362 that I think you were taken to yesterday. This is where he went on to explain that such a person would have read what was on offer there. And my friend's complaint, now framed in paragraph 70A of his skeleton, was that that conclusion was in error, a point that Mr Hollingsworth made orally yesterday. So the argument must be that's just not open to the judge.
I think the submission was there was no positive evidence to support the finding.
Exactly, and it's put that way, that there wasn't evidence of how people find things on the internet. The explanation, no basis in the evidence. And this is elaborated on the last few lines of the subparagraph in the skeleton, where it's suggested a detail of the point is that there was no basis that they would have found this Merck website as opposed to the MSD Jobs website that they say was intended for the UK user. Now that is quite important in my submission, because the way that submission is put there is not that you need evidence as to how people do a Google search. The suggestion is that the judge should have been thinking that users in the United Kingdom would have found MSD jobs.com or jobs.msd.com. And on this contention, can I just start by reminding my lords and my lady of the first point that we make in paragraph 35 of our skeleton, and that's how the argument on this is morphed. Before the judge, they didn't suggest that discovery of UK jobs on the Merck branded website, if someone searched for Merck UK jobs, would be unusual or impossible. Contention was simply that this was a US directed website. Now, can I just show you that? You need S3, tab 49, and go please to page 993.
I'm sorry, which bundle?
S3, and it's tab 49, page 993. it's not, just for your note, in case you try and find this again, I'm afraid there's an error in our skeleton. In footnote 11, we say it's page 959. The correct reference is 993. And set out here, paragraphs 35 to 39, the thrust of which is that these are intended for US users. There's simply no suggestion that a user searching for Merck jobs in the UK wouldn't find it. And that explains why the focus of the judge's analysis is on that issue and, for example, the pop-ups referred to. But the judge didn't overlook the point. He expressly turned his mind to how the UK user would find the jobs.merck.com website. And he accepted, as you've seen, our contention that those searching for Merck jobs would find it. Now, as I understand the challenge, the suggestion that that wasn't open to him, is that it's the idea because there was an MSD jobs site that they would have found instead. Can you just pause and think about that? Because it involves an unspoken suggestion that the UK user would actually search for MSD jobs instead. What the judge accepted is that a UK user may search for Merck jobs and find it. If you search for Merck jobs, why, we ask, would the MSD branded website be found?
Well, you might get both.
You might, perhaps. My lord did it yesterday, and you get Merck. You can't get there now because it's geo-blocked, but it comes up. And it's quite clear in my submission that the judge was perfectly entitled to conclude that the UK user searching for Merck jobs in the UK would have found the jobs.merck.com website, and they would have looked at what was on offer there. Don't forget, Merck is a brand here because of my clients. And my Lord Justice Phillips did it yesterday, but you couldn't open it because it's now geo-blocked. And my Lord Justice Arnold was alive to the geo-blocking as the answer if the defendants want to include jobs located in the UK on the Merck.com site. As an aside, one of the things I was going to mention yesterday was that that letter that was sent right at the beginning of, just before the trial, of indicating things that they would stop doing, included indicating that they would stop having jobs located in the UK on the Merck.com website. I'm afraid I looked and it's not in the bundles. I'll make sure that a copy of it is made available. We got it, Phillips. Sounds as if we've got it. So I'll make sure that, perhaps we won't take time to hand it up now, but I'll make sure it's handed up over the short adjournment.
Thank you.
Mr. Brandreth suggests that you might not know the letter that I'm referring to.
No,
yeah. Let me just be absolutely clear.
You might have mentioned it, but if so, I don't remember.
Yeah. I don't want to take a lot of time on it. It was one of the things that I was going to explain about the way in which they behaved in the run-up to the trial. They had written a letter just a few days before trial indicating that they wanted to comply and that they would do or wouldn't do certain things for the future. The judge was pretty scathing about the fact that there was no legal obligation attached to it and they might change their minds, and that he thought that they were just pushing at the boundaries again and again and again. You'll have seen that in the earlier decisions, and the reference to the April letter is the letter I'm talking about. I don't want to take up an awful lot of time on it. It's just that it so happens that this very thing that we're fighting about now, all this time afterwards, in that letter, one of the things they said they wouldn't do for the future, although there was no legally binding undertaking, one of the things they said they wouldn't do was have UK jobs on the Merck.com website.
2016.
15. Yeah. Now, that's it on the jobs instance. The other instance identified for criticism is row Q. This is about documents that you heard about yesterday called safety data sheets. And as you heard yesterday, this is about information sheets that manufacturers and importers have to make available concerning bulk chemical products and ingredients. So it doesn't relate to the finished pharmaceuticals, but there are a lot of people that have to deal with things further up the supply chain, and they enable people to understand the safety implications of those chemicals and ingredients. And the judge deals with this at paragraphs 370 to 378. And the attack that's made in my friend's paragraph 70b airbrushes from history almost all of the evidence. I suspect when reading this skeleton, my lady and my lords may have had the impression that these documents were only on an intranet and only ever seen externally if someone within the defendants took it from the intranet and sent it to them. That's not a fair description of the totality of the evidence at all. Indeed, all we have in my friend's skeleton is a reference to the second statement of Miss Bazile, and in fact just one paragraph in it, and you'll see in the judge's analysis it's much fuller, in my submission much fairer, and an assessment of all of the evidence. And the first point to note on this, something which I think came out of the debate yesterday with my learned friend, is that the SDSs are created for each country separately, including the United Kingdom. And you see, I'm now looking at paragraph 370 of the judgment, UK SDSs were created and available for download. And you see the download symbol described at paragraph 370 of the judgment, including next to it United Kingdom, English. And inexplicably, we say, they were only put on the Merck website with all its Merck branding. I should interject that subsequently, I think my learned friend mentioned, subsequently they have been made available on the MSD website, so enabling interested parties in the UK to access them from the MSD branded web presence. But that wasn't the case. Now the judge explains, this is from para 372 onwards, what he calls the provenance of hosting of the SDSs on a central external resource, being explained by Miss Bazile. And this is a reference to her first statement. But please note, it's a central external resource. And it's quite clear that what's happened is that in line with other companies making these documents available as an external resource, this was something they started to do in 2017. And I just pause there and ask you to note this, and also the fact that you don't do this unless you're expecting some of the people who would need or like access to the documents to access them directly on the external resource. People that might be inclined not to pick up the phone or send an email with a request, they might, particularly in the modern day, be more inclined to just look things up on the internet, assuming they might be available, particularly if other companies are doing it. And they can do just what my Lord Justice Phillips did yesterday when looking for Merck jobs, but replacing jobs with SDS, or perhaps the word safety data sheets, or perhaps even the name of the product. Of course, it may be that some don't resort to the internet first, But many people will do that, and increasingly thinking they can just find it without troubling anyone. But others may contact the company and ask. And it may be, in those cases where there is contact, that MSD employees send a copy rather than direct people to the internet resource. But that's not to the point in my submission. The defendants realise that some users will simply look them up. As I say, no doubt increasingly if there's a trend of companies making these documents available to be just found. And you can see from the rest of Ms Bazil's paragraph 11, quoted in 372, that in 2018 the defendants started to put SDSs for other countries, i.e. non-US, in the same external resource. And that's the basic problem. They stuck the SDSs for people outside the US on the Merck website and not on the MSD website. And we've never been able to understand why they did it like that.
Well, the judges found at 376 that there was at the material time no parallel MSD site.
Yeah, there wasn't. Exactly. It's not. They didn't contend that they did. So they just stuck the stuff that was of relevance outside America, including to the UK specifically. So UK specific SDSs were stuck and only available on the Merck branded environment. And that's basically up to 372 of the judgment, and the judge sets out more of Ms Bazil's first statement in 373. Those details, those paragraphs give more detail as to how they got into the position they did, and explains when the UK businesses, and then explains that when the UK business uses the SDSs, the explanation is of internal use or use as an email attachment, so not the provision of links to third parties. And that's in substance the same as was repeated in paragraph 8 of the second statement, that single paragraph picked out by my friends in their paragraph 70b. So that's what the evidence says. The UK business does not positively send internet links to third parties. It sends actual documents. But in my submission, it says nothing about the instances when a person needs or desires access and decides to look it up on the internet rather than ask for it, which, as I've said, is the whole point of providing an external resource. And at 374, the judge sets out some of Bazil 2, in particular the response to our queries as to why the US SDS was not put on the MSD site and why the non-US SDS, i.e. other countries, were put on a website they say is intended only for the US and Canada. And the guts of the explanation in both these passages is supposedly that what they were doing was quotes for interest. Apparently, US customers might want to see classification of material for a different country. Well, my lords, my lady, perhaps. But the judge was perfectly entitled to take the view that he did in 376, the key paragraph that my lady just drew our attention to, that the information being available to US users out of interest didn't avoid the fact that the material was clearly targeted at users in the UK. They're all UK-specific safety data sheets that, if looked up on the internet, can only be found in the Merck-branded environment. And the judge gives his reason, which was obviously open to him in my submission, that it was the inevitable consequence of UK SDSs being available on the Merck website when there was no parallel MSD site to have them. And he was perfectly entitled to reject the suggestion that this was not part of the business processes of the defendants. That's the top of page 170. Now, the final point on this particular instance is the judge didn't separately deal with the pop-up point again here, as my friend notes, but it's clear from his other analysis that a pop-up would not negate targeting if we have UK-specific material made available only on the Merck branded environment. He's already dealt with that. So, my lords, my lady, that's each of the instances addressed. Can I turn to the third strand of the ground to argument, which is dealt with from paragraph 72 onwards on my friend's skeleton, and it's the trademark infringement only bit, so it's really the second limb, paragraph 3 of the order only, and it matters only insofar as we've currently got a finding against them on both paragraph and 2 and 3. And this, in this part of the skeleton, is the by now very familiar contention that they should win because they do not put their pharmaceuticals on the market under the Merck mark. And as we've explained in our skeleton, we're addressing this, we think, for the 5th time, and the case simply ignores the fact that use in relation to goods and services can be established when use creates the impression that there's a material link in the course of trade between goods and services concerned and the undertaking from which the goods or services originate. So this second limb was clearly identified on previous occasions and was considered most authoritatively by Lord Justice Kitchen in this court. Can we look at that? So I'm in the core supplemental bundle, tab 2, and we need page 121. And His Lordship identifies 2 ways in which use in the course of trade in relation to goods and services can be shown. So I'm on page 121. The first is straightforward use by affixing. That's used to distinguish, so that's paragraph 172. But the second is paragraph 173. And that was picked up by Sir Alistair in the remitted hearing and the judge on this application. And I can kill 2 birds with 1 stone here by reminding you what the judge said in paragraph 181 again. I think I've showed you this already, which sets out Sir Alistair. So I'm in the judgment. Sets out Sir Alistair. It's the passage where the judge added his own underlining right at the foot of page 129. I'm pretty sure I showed my lords and my lady that earlier this morning. And as we point out in paragraph 39 of our skeleton, this is the top of page 66 of the bundle, the fact that the mark affixed is Merck Sharp Dohme doesn't prevent the link occurring. Never did on the previous 4 occasions the point was argued, and it still doesn't. And that really is that. Now, my lords and my ladies, I've got to the end of my note on ground 2. That's all I intended to say, unless you have any further questions for me on that. So, can I turn to ground 3 then, please? There are 3 separate points on construction under 3 separate subparagraphs of paragraph 4 on this. And before turning to any specific provision, my friend at paragraph 80 of his skeleton set out an extract from paragraph 105 of the remitted issues judgment. So this is Sir Alistair's second judgment, and it's in that where he explains that his practice has been to endeavour to indicate what would in particular circumstances constitute compliance. And what that is directed to is what could be done albeit that there was no obligation to do so. There was, for example, back then a hot debate at the time as to why they wouldn't adopt geo-blocking. My friends were very resistant to it. Over time, they've adopted it in dribs and drabs. My Lord Justice Arnold mentioned just a few minutes ago that that's part of what they're allowed to do to comply. And that's what paragraph 105 was really directed to, that kind of thing, providing for something that if they positively do it, they wouldn't be held to be in breach, but not saying they had to. Now, my friends in their skeleton have underlined almost all of the second half of this passage, but they omitted the words in brackets referring to being in technical breach but having strong mitigation. You can see when you read all of it, including those words, that the judge is certainly not saying an honest endeavour to follow the guidance will necessarily mean no breach. Those words that they failed to underline clearly contemplate there might be, but the consequence may be good mitigation. Now, it's a bit puzzling as to why this is even in my friend's skeleton in my submission. It appears to be the premise for the complaint in paragraph 81, which suggests there was an error in the way the judge interpreted one subparagraph. And that's a very strange criticism, because the reference to the judgment given here is to paragraph 119, which is concerned with paragraph 4H. And we're going to come on to that, but you're aware it's about the inadvertent breaches that are corrected. So it's not the kind of thing that's being described in paragraph 105 quoted at all. I mean, it seems a completely random reference in my submission. It's just not the kind of thing that that Sir Alistair was referring to there at all. I mean, I think they perhaps hope that you'll think that it must be because it happens to be in paragraph 4. But it's clearly not what he's talking about. Nothing to do with what he's talking about there. That brings me to my friend's specific complaints as regards the individual subparagraphs. So let's deal with them in turn. The first one is 4B, concerns links from an MSD branded UK specific website to Merck.com. And my learned friend argues for a construction of UK specific websites that encompasses websites that are not specific to the UK, so long as they are in part targeted to the United Kingdom. And that's the essence of the dispute. Before I get into the detail of the argument, I want to draw attention to two important practical points that arise here. The first point is that what my friend is actually arguing for is for a construction that strikes through the words UK specific. And the reason this is so is that this is an exception to what otherwise is prohibited by paragraphs 2 and 3. And it's common ground that those paragraphs only cover online material if it's targeted to the United Kingdom. So it may be targeted elsewhere too, but it must be targeted to places that include the United Kingdom. On my construction, the words UK specific are doing some work. They're limiting the exception to only those websites that are only directed to the United Kingdom. And as I shall explain, there were such websites at the time of the order. But my friend's argument is the exception covers websites targeted at the United Kingdom, whether they be only targeted or whether they're non-UK specific, so long as the UK is part of where they're targeted. I'll just pause and, as an aside, draw attention to a further striking feature of this argument. My friend would have it that although we've all been using the word targeting not just in this case, but in this field for ages, what happened here was that a new term, UK specific, was coined to mean exactly the same thing that everyone else had been referring to as targeting the UK. Coined just for this paragraph of the order. One only has to state that to preach the far-fetched nature of the contention. So the first practical point is my friend's argument is basically giving no meaning at all to the words UK specific by arguing that they mean the same thing as targeting. And my friend is rather matter of fact acknowledging that in his paragraph 87. I think he's trying to deal with the issue. He suggests the words are there to reflect the fact that only UK specific websites are within paragraphs 2 and 3 in the first place. So,
From circular.
yeah, it's completely circular, but that's, I mean, he realises he's got to deal with the obvious point that I was going to advance, and that's his way of dealing with it, in that rather matter-of-fact contention. It's no answer at all in my submission, but what it does reveal is that he accepts the words are doing no work at all. His construction is precisely the same as if the provision simply said MSD branded websites. Now the second practical point is this. As this issue currently arises, it pertains only to the news releases and company statements complaints that we've looked at already. But my lords and my ladies should make no mistake. If my friend persuades you he's right on his construction, he can set up his msd.com website with as many links to merck.com and as much promotional and informational material as he likes in the Merck branding. As long as he has the fig leaf of the pop-up, the whole regime can become, or start to become, integrated again. This is a very real prospect, and it wasn't remotely what was contemplated when the order was made. Now, the passage of the judgment that's criticised is paragraphs 475 to 477. This is where my friend says the judge went wrong in his paragraph 82 of his skeleton. And they're the paragraphs of the judgment that I skipped over when we were dealing with news releases before, when I was looking at targeting. So they start at the bottom of page 189. And you can see that the judge recounts, this is the top of page 190, that he was shown paragraphs 114 to 117 of the remitted issues judgment along with others as pertaining to this. And the judge says at the end of paragraph 475, it's useful to have in mind that it's the actual wording that has to be applied. So he's interested in what happened below, but it is the actual wording that has to be applied. And that is an important point my friends don't face up to in my submission. What my friend does is set out some, but importantly not all of paragraphs 114 to 117 of Sir Alistair's judgment. And there's some judicious editing in that. Before we turn it up, can I just remind my lords and my lady that at the time of the trial, msd.com was not a website itself. It simply redirected to merck.com. That's a point we point out in paragraph 47 of our skeleton. And there were 2 UK-specific MSD branded websites. MSD-UK and MSD Animal Health. One was a .com, the MSD-UK, and the other was actually a .co.uk domain name. But there were two UK-specific MSD-branded sites. The next thing to remind my lady and my lords of is that by the time of the remitted issues hearing, the defendants had begun to develop MSD.com as a non-US global website. That was a point that I think my learned friend Mr Hollingsworth was keen to emphasise yesterday. And the other thing to remind my lords and my lady was that the judge had to grapple with how to frame injunctive relief in light of the fact that there had been what under German law was considered an equilibrium. That was the consequence of my client not complaining early enough, being too cooperative, if you like. It was not the much more aggressive online expansion that had come about more recently, due to and following the merger with Shearing Plough in 2009, but the much earlier encroachment into our rights which had been tolerated. And that is important because the passage that my friend relies upon is in the passage addressing that issue, how to frame injunctive relief to accommodate that point. Can I show you that, please? So it's the supplementary core bundle, tab 4. My friend relies upon 114 to 117, or bits of it. Can you please pick it up at paragraph 108 on page 188? Here, you see the judge explains he has to take account, in fact, of three matters. I'm in paragraph 108 in the middle of the page. The first and third are simply that the 1975 protocol varied or clarified the agreement and there was need for time to make adjustments. The second is the point that I've just mentioned, the equilibrium. The apparently inconsistent acts undertaken by Merck US and tolerated by Merck Global. And he says he's going to deal with that issue next, which he does from paragraph 109 onwards. First by saying it is in fact impossible to identify the precise point when, following the Shearing Plough merger, the equilibrium was disturbed, and that the disturbance obviously caused a significant problem because one's trying to take account of an equilibrium that's in fact no longer the current position. And it's in the context of this discussion how to address this issue in the injunction, the equilibrium that had been established but then later disturbed, that paragraphs 114 to 117 appear. And paragraph 114 actually starts by reciting that Merck US had already taken some steps by the time this remitted issue hearing. Perhaps not surprisingly, given the result in the Court of Appeal. And we see Sir Alistair explains that they'd removed from Merck.com material of which complaint had been made relating to events, opportunities and contacts. And at little 2, note this, that in parallel is developing an MSD website with revised architecture linking it to new MSD related websites, things like MSD responsibility, using the word Merck only in the form authorised by the 1970 agreement. And just to be clear about that, because my friend yesterday said they could use Merck & Co with a geographical indicator. It has to be a geographical indicator in the agreement which identifies them as being from America. The judge here also refers to some geo-blocking that had been adopted for 3 specific websites, and also refers just above halfway through this paragraph to the fact that the defendants said they did that not because they recognised any obligation to do so, but simply because they chose to, and they offered no undertaking to continue the arrangements or adopt them in relation to any new sites. And the paragraph goes on, and this is where we pick up the text my friend quotes in his skeleton, that Merck US identified a number of respects in which it's not possible for the MSD site to be a clone of the Merck.com site. There will therefore remain rare instances in which MSD sites are required to act as portals to the Merck.com site. One example is the link for investors affording access to financial information in compliance with regulations. And there appear to be other occasions where Merck US has taken policy decisions not to put information on the MSD website, but to place it on the Merck.com website. And he gives, as an example, information contained on its corporate site. I think that was information as to corporation and its governance. Can we just pause here, please? Please note this is expressly about rare instances. Moreover, it's about 2 types of circumstance. First, where there's some specific requirement, investor information is an example. The point was investors outside the US had to be able to get at the same information in the same place. And second, there's also mention of instances where Merck US had taken a policy decision. But that's not to say this is about Merck taking further policy decisions in its own discretion to do this more. Don't forget, this is all about the equilibrium. This is all in the context of how to deal with the equilibrium, which had already been taken place, and indeed part of the equilibrium from back before the disturbance. And the judge went on in paragraph 115 to say he considered a legal and enforceable framework was needed, and that what that was to treat Merck.com as falling within the scope of the general prohibitory injunction, but subject to specific carve-outs. Now, just pausing here, what the judge has done at this point is identify that there will be rare instances, either because of necessity or a policy decision, that Merck US could claim to be entitled to continue under the equilibrium. He hasn't purported to identify the precise number or scope of the rare instances, but we see he's given an example. But the precise scope was obviously something for the form of order hearing, where the specific form of the order drafted was to be addressed. And what my friends are seeking to do is to treat the following paragraphs as if they're said to be part of that drafting exercise. And specifically, the judge went on in paragraph 116 to identify that the carve-out he's just said he will adopt in the light of treating Merck.com as within the prohibitory injunction would relate to any link from an MSD website to a Merck.com website which generates a pop-up. And also at the start of para 117, where he refers to the detail of the pop-up in his introductory text, refers to Merck US partly through necessity and partly through policy, intending to retain some links between MSD.com and Merck.com websites. Now, as I understand the argument, it's contended that this is indicating that all and any link from any MSD branded website is intended to be covered. Obviously, if there's a pop-up, but as many as they like could be piled in the future. And what that argument is plainly seeking to do is to go much wider than the rare instances of either necessity or, insofar as there was a policy decision, those instances in the equilibrium. My submission to my lords and my lady is that it is not possible or fair to read this whole section as meaning that. nor would it make any sense, because it would in substance be giving my friend carte blanche, as I've already said, to ramp up and adopt links of this kind on a massive scale. All from a section in the judgment dealing with how the judge intended to address the issue of the equilibrium from prior to 2009. All the judge is doing here is referring to the fact that there will be a carve-out to accommodate what he's referring to. He's not attempting to frame it here, and certainly not saying it will apply to absolutely any link at all. My lords and my lady will note he refers to msd.com sites, plural, in paragraph 114. And again in paragraph 116 he refers to links from an msd.com site. On each occasion in quotes. What he's doing here in my submission is referring not to a single website at msd.com, but the MSD branded domains as a group. So clearly intending to cover msd-uk.com, for example. Which was one of the two that I drew attention to as existing at the time of the trial. This use of msd.com sites, plural, or reference to an msd.com site in quotes, it's not actually intended to be a reference to a specific MSD domain name in my submission. And he's identifying that he will frame one or more carve-outs to cover the rare instances that he sought to explain. He's not saying there's a broad carve-out to cover as many links as Merck US choose to put on their web presence in the future as they like. And the way in which this played out in the order is in fact 2 paragraphs. Can we look at the order? So this is, I think, in tab 10 of the core bundle. It's actually attached at the back of the application. And if you go to page 228, and the first paragraph I want to show you is one that we've not been fighting about. It's subparagraph 4G. That's the investor material that he was talking about. And that doesn't need a pop-up at all. So that one, when it came to drafting it, was dealt with in that separate paragraph. And the other paragraph is the one that we're on. Paragraph 4B. Limited to links from UK-specific websites. And here he's not using the shorthand msd.com quotes websites. He's talking about MSD branded, so it doesn't have to have that domain name, but it's limited to UK-specific websites. So the msd-uk.com and msdanimalhealth.co.uk would be covered. And that general point, that what was intended intended to reflect the current arrangements, not to allow expansion, was part of how the judge dealt with it at the form of order hearing before him. It was on a different issue. So I don't want to put my case too high, but you can see that he's looking backwards, not forwards in time. And can I take you to supplementary core, tab 5. So this is where he was arguing about the actual, he wasn't arguing, he was determining the argument about the form of order. Tab 5, could you go please to page 200? paragraph 8. And as I think my friends point out in their skeleton, what the dispute was afterwards was whether it could link to any Merck branded website, not just Merck.com. So it's not directed to the words UK specific because that was agreed. But what is of note, I say, is that the judge preferred our approach because of the reason that it was intended to be confined to current arrangements. See that reflected in the submission at fourth line down. And his reference to preferring ours and reflecting the equilibrium. It's not intended to provide for the ability to massively expand these links, which, as I've said, my friend's construction would allow. It was intended to cover rare instances in the old fact pattern, reflecting some protection of the equilibrium. And the way that turned out in the order is a separate paragraph for the investor information, and it was limited to UK-specific MSD branded websites. And of course, I also rely upon the language itself very heavily. And I wish I'd thought of the point that my Lord Justice Arnold put to my friend yesterday. His construction obviously does mean that a website like the Amazon.com is a UK-specific website on his construction. And that short and simple illustration destroys my friend's contention in my submission. So that's what I've got to say about that subparagraph. I was going to move on to subparagraph 4D unless there's anything that my lords and my lady have on that one. This is all about the use of email addresses ending in @merck.com. And the issue is whether the order permits my friend's clients to use and promote generic @merck.com email addresses for communication by and to the UK public. And what I mean by generic email addresses is those that are not email addresses for any employee, but one of the kind we see increasingly to communicate with a company rather than a specific individual. So it might be inquiries or help for mothers or complaints or a drug name. Just about any subject matter at msd.com would be an example. It's those kinds of email addresses. My lords and my lady have seen them. It's a way to communicate with a company where there's no need or desire to be in communication with a given employee. Typically, you'll never know who reads or deals with the communication. In fact, in the modern world, it will likely be a team that changes over time. Probably will even involve some kind of automation, perhaps even AI as we go forward. Much the same way as a chatbot. There is, in fact, a specific example of this covered in subparagraph 4E of the order. So I'm back in the core bundle at tab 10. It's dealt with separately, page 228. This is the generic email address medicalinformationuk@merck.com. And why we've got that is because it had a role to play in receiving inquiries that couldn't be changed without regulatory approval. And it also needed a very long run-off period even after approval to change it was obtained. No doubt because there would be material out there in the world with this email address included. And so what paragraph E did was to provide for this email address, just this one, to be allowed to be used whilst that regulatory change was made, and then for a period of 5 years after regulatory approval to change the address to one that didn't feature the sign Merck.
And your point is that this is redundant if D is construed as contended for by the appellants.
broadly, I draw attention to it to point out that the intention was for the defendants generally to cease using it, and broadly the point that my lord makes is right. Of course, I don't want to push that point too far, because they can come back and say, well, not so if the people dealing with that were all based in the United Kingdom. So I don't push it too far. It's not absolutely redundant, but I do say that it does show that it could have been dealt with in that other way by having people elsewhere, and so it's not completely at odds, but it doesn't sit very well with their construction, my lord, is the way I would put it. Now, in addition to this point on that particular generic email, and the fact that I say that generally the use of Merck.com email addresses was understood to be prohibited, that's why that had to have an exception. There was a further issue that arose about employees' work email. And broadly it's this: did they need two separate emails, joeblogs@msd.com and joeblogs@merck.com, and have to remember for each occasion which one to use? Or did all employees have to switch to MSD? How did you deal with employees? And that's actually what the provision we're fighting about is addressing. That's what, at its heart, this provision's dealing with. Again, I would make a similar point to the one I made on the links as to a practical consequence if my lords or my lady tell the parties that the order does permit the use of generic @merck.email addresses directed to the UK public. There's going to be inevitably a very substantial increase in that. We will see the defendants chomping at the bit to roll this out. My lords and my lady can rest assured it will happen on a substantial scale. And as to that, do not overlook the history of the dispute and the earlier conclusion of the previous judges as to how my friends approached the issue of online use of Merck, constantly pushing at the boundaries and intending to link MSD with Merck. So as a practical matter, it's important. This is what's at stake. Can I turn to the detail of the argument? My learned friend at paragraph 89 of his skeleton points to the fact that the email addresses were part of the equilibrium established at the first trial, and he specifically refers to paragraph 124 of the judgment. Can we turn it up? It's supplementary core tab 1, and we need page 38. And the first thing to note is this is dealing with the equilibrium as it impacts on both the use of the Merck.com domain and the email addresses that include that. So it's not simply concerned with email addresses. And just for your note, this issue actually starts back at paragraph 115. It's a section directed to the use of both, as you see there. And that by the time of the trial, that had been going on for about 2 decades. but which had been ramped up and aggressively promoted more recently since about 2009. And paragraph 124 that my friend refers to is the paragraph that follows the consideration of the German law principle of equilibrium. 124 is a long paragraph that recounts how MSD had pushed the boundaries over the years and how the complaint as to the use of Merck.com, the Merck.com domain name and the email addresses was never resolved after the initial complaint in 2005. This is by the bottom hole on page 38. And the judge concluded it was honest in the sense of not a deliberate contravention of the agreement. That's about 8 lines from the end of the page. And over the page, the judge concluded a state of equilibrium was established in relation to both the Merck.com domain name and @Merck.com. So that's the email addresses. That's just above the top hole. But he says that did not necessarily reflect how things then stood. And he refers to the enlargement of the business. This is the shearing plough merger and the adoption of other variants like MerckForMothers.com. And he also referred to extensions onto things like YouTube, Twitter and Facebook. These were the matters that disturbed the equilibrium. The judge deals with those newer variants like Merck for Mothers in paragraph 125 and basically says they must stop. And he returns to the Merck.com and @Merck.com email addresses in para 126. My friends do mention this paragraph at the end of their paragraph 89, but perhaps in my submission don't acknowledge its significance. This paragraph explains the YouTube, Twitter and Facebook use must stop. And in the second half of the paragraph, the judge addresses how to deal with the enlarged use of Merck.com and @Merck.com email addresses. And he says they must adopt localised national email addresses for non-US based staff, where that doesn't occasion unreasonable expense or disruption. And he explains that this is replacing strict compliance with the 1970 agreement by an obligation to comply with such orders as the court may make designed to avoid any increase in confusion arising from the email addresses beyond that established under the earlier equilibrium. Now, my lords and my ladies should also look at the Court of Appeal. This is paragraph 217 onwards. This is tab 2, page 130. Now, this is the part of Lord Justice Kitchen's judgment where he's just set out the German law principles of equilibrium. The section actually starts at 213 at the bottom of page 129, where if you're interested, you can actually see the proper German name of this principle. I'm not going to try to pronounce it. It's in the second line of paragraph 213. And at para 217, the judge's findings are summarised. The first aspect in para 217 is the domain name and email addresses being analogous to a company name, which the 1970 agreement governed. That was actually, just as an aside, that was one of the main issues on the appeal. My friend was seeking to establish that the agreement only applied to trademark use, not company name or trade name use. Second, this is para 218, refers to findings of use since 1993 of the domain name and @Merck.com email addresses, but notes the more recent pushing at boundaries, first as to things like Merck-UK.com, over the top of page 131, where Justice Kitchen refers to the conclusion as to honesty as to the use of Merck.com and @Merck.com email addresses. And the third aspect, para 219, summarised here, is the state of equilibrium in relation to the domain name Merck.com and the @Merck.com email addresses. But this is after the merger with Shearing Plough. There was much larger use and much more aggressive promotion, seeking to attract a global audience. And the paragraph also mentions those other Merck branded domains like Merck for Mothers and the use on YouTube, Twitter and Facebook. Now we can skip over the fourth to the fifth aspect, which is directed to the Merck.com domain and @Merck.com email
This is
addresses.
just quoting what the judge said, isn't it? It's a paraphrase of what the judge
He's
said.
going through it, yes, he's going through what the judge said in quite some detail. And if we look at page 132, after recording the contention that it should have applied to trademark infringement in addition to contract, that's para 223, we see at 224 the contention my friend was advancing, that equilibrium reflected a reality of a degree of overspill. And at 225 we see the same old characterisation of our complaint being a frost descending on the relationship. I think that's repeated in the skeleton for my lords and my lady in paragraph 6 this time. And importantly, 226 says there are a number of difficulties with the submissions that my own friend had made, that they didn't take due account of the judge's factual findings. And at the final line of the page, this was not mere overspill. Importantly, the sentence bridging the page, all the activities were likely to increase the risk of businesses, goods and services of one party being taken for or being connected with those of the other. And para 227 emphasises that MSD had disturbed the equilibrium. They were not an organic growth, but a step change in activity. You see that in the middle of paragraph 227. And 228 refers to the fact that they did this, pursued this course of conduct in the face of objection by my client. And the conclusion, para 228, was that the German doctrine of equilibrium gave my friend's clients only limited assistance. So, my lords and my lady, it's far more nuanced position than one might think reading my friend's skeleton, namely that all and any use of emails with an @Merck.com email address is fine and within the protection covered by the equilibrium. Not so. And of course, if that were true, there'd be no obligation to have MSD.com email addresses at all. And the passage I showed you saying that national email addresses were needed was the judge's decision as to how to deal with the issue where historically there'd been an equilibrium, more modest use, but that had been disturbed in a step change way, as we've seen, by the defendant's conduct. So that's what happened up to that stage. If we move forward to the remitted hearing judgment, what actually arose at that point in time, or actually now might be a convenient moment.
Yes, all right. We'll resume at 2 o'clock. How are you doing time-wise?
I'm doing very well. I've not got, I should be done in less than an hour.
Okay.